Okay.
All right, welcome everyone to November 2nd and our version of Bar Talk today. We have a special guest, Chief Judge French, that's going to be joining us. Right now, we just wanted to work through a little bit of our agenda on our slide, and then we'll introduce Chief French as soon as we address those things. So one of the things that there have been some changes since October 26th when we last had Bar Talk. One of those is that we have a new proclamation for our state of civil emergency. You've probably heard on the news that issued for 30 more days. So I think we're on for November 29th. We're going to have to look at renewing that. And then for those of you that are involved with family cases and visitation that the department might be involved with, or HCI in particular, there are some new provisions that we posted that DHS issued back on the 28th or 29th of October. Feel free to look at those. They talk about children wearing masks and the questions you need to answer regarding fever, etc. All right, and then, of course, yesterday, Governor Mills announced an extension or some changes to our COVID-19 restrictions, which I believe go effective on November 4th. So I encourage you to read that at the governor's website if you think it's going to affect your constituency, and in particular the travel restrictions that might be on out-of-state visitors too. Now, was there anything in particular, Angela, that came to mind on the November 1st order from our governor that I didn't just mention?
No, sir.
Okay. All right. Now, those of you that have joined us for our special guest, Chief French, looking for you on my Zoom, and I'm not, oh, there you are. Chief French, I see that you're here. Thank you for joining us again for another edition of Bar Talk. And, you know, one of the things that we, you know, we're all kind of interested in is, and this is going to be kind of the subject of my next article in the Bar Journal, and that is how our court shutdowns are essentially affecting our rule of law. And, you know, you hear all these advertisements about, you know, go vote. That's what your democratic right is to do, etc. Well, as we all know too, part of keeping a stable government is to allow people the ability to depend on their agreements being enforced. And I know that as a chief of the district court, and of course you've got a chief of the superior court, you're trying to keep those courts open for us and implement new ways to resolve disputes, which we really appreciate. PMO SJC 7 was a lot of help, as well as PMO SJC 2 related to remote proceedings. And we had talked just a little bit before you came on about our interest in the backlog and how you guys are managing that and how we might be able to help as attorneys too. So with that, Chief French, thank you for joining us. Are you, can you hear me okay? Are you connected okay?
I believe so. I can hear you. Thanks for inviting me and having me participate. What I'd like to do is just to go over a few things that I know are updates. And if that doesn't answer the questions, I'll be happy to answer any questions and respond specifically to what you just spoke about. But let me just go over some of these things first, mainly because I prepared in that order, and hopefully that will be helpful. I'll certainly leave time for questions before we finish this morning. So the first thing I just want to discuss, which is the way that I ended my day on Friday, was with the conclusion of the Court Improvement Plan Child Protective Conference, which was redefining the role of a child welfare professional. And I bring it up one more time only because there are some administrative things that have to be accomplished for those that participated. Excuse me. And if you didn't hear the conclusion, you may not have heard those things. So I want to go over those just briefly to make sure everyone that did participate understand what they need to do going forward. A credit reporting form will be emailed to all those participants who previously received conference communication from the Family Division. There's also a link to the reporting form on the conference website that anybody can fill out to get credit. In addition to the credit reporting form, participants are required to fill out the conference evaluation form as well. And a link to this form will be emailed out to those, again, who already received communication from us, and there will be a link on the website. Both of those items need to be completed by November 20th. And once both are completed, the credits will be submitted. So I just wanted to bring that up. The other thing, as previously mentioned, is most of the sessions that were offered at the conference were recorded. And if you'd like to view the recorded sessions, you can email the Family Division and request to be able to do so. And those requests will be accepted until November 6th. And there are certain limitations on getting credit for video, but I don't want to go into those this morning. So that's just the update, but it's also a good segue to the fact, or to the way that we all are trying to adapt to living in the COVID world. We were actually going to go forward with that CIP conference in person at Sunday River last April, and we had to cancel at the last minute, and the Family Division was able to put together a way to do so virtually and have folks enjoy doing so remotely, which I think was a great success. So that's just a segue about how things are changing. Some other things I wanted to bring up. One is small claims. Now I'm going to answer your question about, you talked about backlog, but before I do that, I just want to bring to everyone's attention, for those that file small claims complaints, just to make sure everyone knows that a new form was promulgated in July, I think, of this year. And that form is a little different from the old small claims form. And the rules of small claim require that a filer use that form. And that will start to be enforced as of December 1st. So if anyone files a form without complying or using the form, it will be returned as an incomplete filing. Some of you know and have heard that courthouses have been unexpectedly closed. And this has happened for different reasons over the past number of months. Obviously, one that happens quite often is weather. In fact, at the last storm we had, a couple of courthouses were closed completely, and one for a couple of hours because the courthouses lost power. We're also closing courthouses because of limitations on judicial resources, such as marshals and clerks. And if you listen to Chief Justice Mullen last time, he spoke about the use of marshals within courthouses. And it is our policy that there be a judicial marshal conducting entry-level screening at every courthouse. So if we have the unavailability of a marshal, or a marshal suddenly becomes unavailable, it may result in courthouses being closed. If a courthouse is closed unscheduled, at a last minute or pre-planned, that will be on our website under closures. There's also a banner across our website that talks about updates or emergencies. I apologize, I don't have the exact wording, but if that banner is going across the website, you can click on that to find out what's happening as well. In all cases, or in most cases, except for example, a loss of power or closing for snow, it's not uncommon to still have clerks answering the phones or the service center answering the phones. So lawyers and litigants should certainly feel free to call, and should call ahead to make sure the courthouse is open, or to find out what to do if they don't have access to the courthouse they expected to access. We understand this is a problem. We're trying to do the best job we can do, making sure the information is provided on an ongoing basis. It's just, again, one of the realities we're living with with regard to the limitations of our assets during the COVID crisis.
Chief French,
Yes.
on that very topic, and that issue that we did have come up that was forwarded up the chain, excuse me. What if there is a deadline that someone needs to have a motion filed at a certain court that closes unexpectedly? Are we allowed to just bring it to another court in the county for filing, or are we to treat that like a storm closing and make sure that we get there the next day and get it filed?
You should probably treat it like a storm closing, although that's a question that could be asked of the service center or the clerk. There may be other ways of getting those pleadings taken care of, which will be another good segue in just a moment. The other thing I'm going to add about that is that every time a courthouse is closed, if it's a district court, I'm required to sign a closure order for that very reason, because it tolls or stays the filing requirements because the courthouse is unavailable to the public. Okay. So the other thing, and let me just talk a little bit more about this, and this is foreshadowing. I know Chief Justice, Acting Chief Justice Mead and Justice Mullen both spoke about this as well. The SJC and the trial chiefs meet and the chief administrator meet regularly. And we're doing so not only in response to issues that arise at the last minute, we're also trying to be planful and look at those issues that we foresee arising in the future. So when you hear as a bench, litigants hear about changes that are happening, decisions are being made quickly, which isn't necessarily our preferred method of doing business, but sometimes it is a necessity. Having said that, I'm going to foreshadow about some of the things that I expect you'll be hearing from us about soon. And I can't guarantee this is the case, but again, it's a good foreshadowing and you should expect to hear some things. One is we're looking seriously at allowing an electronic filing of pleadings. Again, we previously allowed for that and it was draining judicial resources. And I think we may have found a way to address that. So that may be available soon. If that's the case, there'll be a pandemic management order that indicates that case exists. So that should solve one of the issues that you just raised with regard to filing. Although I'll let you know, one of the discussion items we had is when those items become docketed. Remember, for Odyssey, which will start up in November in Bangor, it's not only electronic filing of cases, but it's docketing and storage. We're still using the NEGIS in the rest of the courts, which is not an electronic filing and or storage. We still use paper files. So we've had to work some things out, and I think we're going to have a solution. So you should hear about that shortly. The other thing is that as we look at the limitation on judicial resources, we recognize that we're not able to keep up not only with our priority cases, but some of our other cases as well. And our pandemic management order suggests that although we have these different phases, we may revert back to prior phases. We may have other restrictions or limitations depending on how the courts are being affected by the pandemic. I think it's likely that civil filings or civil cases, such as small claims, disclosures, land use violations, foreclosures, and other general civil matters, will likely not be heard till after the first of the year. And I expect that you'll be hearing from us more formally about that as well. Not saying that folks that have those issues are not important, but we have to go through our priority cases where people's constitutional rights and safety are at risk. I believe everyone is familiar with the priority list that we have, including family and children before those cases that I just discussed. The other foreshadowing will deal with the virtual background question that has been brought up a couple of times about whether or not there'll be an allowance for folks to use virtual backgrounds for many different reasons. And
now, excuse me, Judge French, are you talking specifically about PMO SJC 7 subpart C as one of the requirements that discusses not being allowed to have a virtual background?
Yes. That,
Thank you.
again, my expectation is there'll be further amendment to that most likely will allow it. There are competing interests, as you may imagine. One of the requirements of that same PMO is that folks conduct themselves in the same manner as they would in the courtroom. And you may all have been on Zoom meetings, or maybe you haven't, where someone speaking has a background which probably doesn't have the solemnity of what's required for a court proceeding. So we just need to work with these things as well. But we're trying to do everything we can to meet the needs of the public while still preserving those things which are important to the court. So that's a foreshadowing of things that you might expect to see coming soon. And we'll give as much notice about that as possible. One of the questions I think I had, Attorney Day, from you was about when we issue new phase management orders or amend the plan, whether there could be a clarification about what the changes are. And if we haven't done a good job with that in the past, our communications folks will relook at that. And I believe the press releases, for example, usually show what the specific changes are. So we'll just make sure that's more obvious to the public and to the bar to make sure they understand what those changes are, so they don't have to read through the whole pandemic management order or the phase management plan, although everyone is certainly encouraged to do so and welcome to do so.
And Chief French, I did want to thank the court too for if you drill down one more click off your website in the pandemic COVID-19 page, you can actually, for the longest time, it looked like you couldn't get just a sheet that had all the PMO orders, for instance. But there is a way off your website where you can click for pandemic orders, period, and you can get them in order by number, as opposed to edit date. So that's helpful to have that available, as opposed to just working off the regular COVID-19 page.
Good. You talked about backlogs and you asked the question about how our backlog is. And the answer to that question depends on the definition of backlog. And some cases have been filed, but they have not been scheduled. Small claims, for example, thus far. So on one hand, every one of the cases is the backlog. On the other hand, we haven't scheduled any yet. So none of those are behind schedule, if in fact we were setting a time frame for doing so. With regard to forcible entry and detainer cases, the evictions, we expected that there would be a larger number of filings than we actually have received since those cases were allowed to be filed. And we are keeping up what we believe fairly well in addressing those expeditiously, at least with regard to the first case management conference, or the first meeting we're having. I think most of you know that the way we're conducting those now is that there's first a meeting with the judge by telephone or by Zoom, and there's a determination whether or not agreements have been reached, if one or more of the parties has shown up or not shown up, and whether mediation is appropriate. One place that we are experiencing, well, let me back up. As you know, we once were able to handle very big dockets very expeditiously. And a good example of this would have been small claims, disclosures, arraignments where folks are summoned, not those that are in custody. And we would handle large numbers of cases and we could get them through the courthouse quickly. And we can't do that for a number of reasons, mostly to protect the safety of court personnel and those also the public that are entering into the bar and the courthouse. And because of that, we're not able to get to those same numbers. And that is creating a backlog to the extent that we're not reaching those cases in the same way we once were. And we'll hopefully get some input on ways to look at that differently, and perhaps we can find some solutions. And we welcome any input from anyone at any time about possible solutions that they may have. The other thing you asked is what else the bar can do to help. And I will tell you that I don't cite any particular instance or suggestion anyone hasn't done this, but I just would like you all to acknowledge that just as each of you continues to adapt your life in this post-pandemic or current pandemic world, the marshals and clerks at the courthouses have done so as well. And the ability to work remotely for them is very, very limited. And I will let you know that the tempers of some folks that enter the courthouses is beginning to fray, as it is with everyone, because of the stresses that each and every person is facing. And oftentimes the clerks and the marshals have to face this. And even if it isn't a member of the bar, if in fact they have a meeting or a discussion with a member of the bar afterwards, please just understand that we're all dealing with this in a way. And if you haven't thanked your clerk or marshal lately, I'd ask that you do that, because we certainly appreciate the work that they continue to do. The other thing, as things change, and you mentioned earlier, Attorney Day, that the governor issued some new guidelines, we've seen a real ripple effect, and I'm sure everyone else has as well, that even if you or someone in your family doesn't have COVID or symptoms of COVID, there are teachers or daycare providers or other institutions that have a ripple effect upon other people. So we understand this is constantly changing, and it's a moving target. We all just need to adapt and adjust to the extent we can. So those are the only prepared things that I had to offer, but I'm certainly be happy. Oh, there's one more thing I will say. We had requested money, COVID money, the judiciary had, for some upgrades, both technology-wise as well as PPE, protective equipment. And it looks like we may be getting some of that. So we may have some technological improvements happening before the end of the year as well. More to follow up with that.
That's great, Chief French. That's good to hear, because I can see where it's helpful even just to have things at the entrance of courthouses for, those that might need it too. So I understand that we do have some questions for you. And Angela, I thought I just got a note
Yes.
from you.
I have a couple of questions.
Thank you.
So an attorney stated that he was told by a family law magistrate quite recently that the standard for having family law hearing in person was it would have to be really, really, really important. So is that your understanding as well? And could you give us some data points to suggest what would and would not meet this standard?
Unfortunately, those decisions have to be made on a case-by-case basis. I will say, if I were hearing a family law case and there was a request that it not be done remotely, some of the considerations that I would have would be the availability or the access to technology of everyone involved in the proceeding, whether or not there was a request to have witnesses that were preferable to be in person versus not in person. For example, if there was a request for a child witness or a medical professional witness, that would be important to me. The issues involved in the case may be relevant. If there are documents that an expert has to present to the court, and those documents aren't easily viewed virtually, that might be something. But again, it's really on a case-by-case basis for every judicial officer. No one should hesitate to file a motion if they believe they have good cause and to argue that. And I assure you that each of those motions or requests is being looked at on a case-by-case basis and looked at very seriously. And whether there's an agreement as well, that would be important.
So if an attorney believes that the judge is making this decision without necessarily taking some of those factors into account that you just mentioned, what would be the advice on how the attorney could respond?
I don't have any advice to give other than you should treat it as you would any other motion that's been denied by a court.
Okay. Is the difficulty of lack of judicial marshals due to an inability to hire for an open position, or are there just not enough positions in the budget?
It's not that simple. Yes, all those things. So we have different marshal availability in different areas. In some areas that we may have the positions available, we don't have the applicants. And I don't know why we don't have the applicants. One of those reasons may be, I don't know this for certain, that the judicial branch doesn't compete financially with other opportunities. That's a possibility. In other places, we are limited for the number of marshals because of those budgetary constraints that we have about the number that we're allowed. So it's all of the above. But we maintain and continue to maintain that the safety of the public and court personnel requires that we do screening for every courthouse before we allow the public to enter. So that will continue to be a requirement that we have our marshal available for that.
Has the court considered hiring local law enforcement to cover court for a day?
There is nothing that we have not, there isn't anything that we're not willing to consider or to look at. And any ideas that someone has, we will certainly get to the marshal and to the court administrator. And there may be things that I'm not aware of that might affect the ability or for that to happen. But again, any suggestion such as that is certainly welcome, and we'll get that to the folks that have the ability to make those decisions.
There was a question about family law cases, the default being in person or remote, and they thought they'd read that in the PMO that default is final hearings in person. Is this correct?
The question was actually about I think a magistrate case, and the magistrates are doing most of their things remotely. And so I'm not certain what my answer to the previous question about how to respond to a denial for a request either to do it remotely or in person still remains the same.
Have you received any information about the start of electronic filing? I know it was postponed and then it was indicated that we'd get it a couple weeks notice. Have you heard anything new?
The last thing that I heard, and this perhaps is foreshadowing as well, is that we're still looking for sometime toward the end of November was what I heard, but I haven't confirmed that, and I don't know if there are anything else that's going to get in the way of that happening. But please be on the lookout because something should be coming out shortly.
That's what I've seen for questions. Thank you, Judge French.
That's what I've seen for questions too. Thank you, Angela. And Chief French, I do think that PMO SJC 7 does give us some guidance about remote versus actual appearances for hearings because it had just recently changed a bit ago. I think it tried to address the hybrid issues of hearings. And so I encourage everyone to review that for your particular case that you might have, depending on what type of case it is. PMO SJC 7 is probably going to be the driver of how you argue whether you want in person, not in person, or some sort of hybrid version.
And I'll just clarify that the presumption is for family matters to be remotely except for contempt, as was said, I think.
By Ms. Robidas in the chat. That's my understanding of it too. And thank you, Chief French. Chief French, are there any alibis you have before we go to finish our business updates and try to finish somewhat on time?
There was one further question, if there was a sense of when the courts will get more caught up on family matters.
I think we're making pretty good movement at that at the moment. The trial time that's available, everyone probably knows that most cases are resolved through the magistrate process that involve children. Those that aren't resolved by agreement or after mediation are pre-tried, and those pre-tried cases are then put before a judge to be heard with the other cases that the judge has that don't involve children. Each judge has a certain number of days available to conduct trial time. And because other case types, such as small claims, aren't being heard, those days are available now at pretty much the same rate they were pre-pandemic. So slowly those will be getting caught up. I don't know that the delay is any longer now than it would have been pre-pandemic, but even at that point, the delay in getting a case heard could be 3 or 4 months from pre-trial until final hearing.
Well, thank you very much, Chief French. With that, we are over in time. I did want to just give Angela and thank you, and I appreciate the time you've given us, Chief.
Okay.
And
thank you.
Thank you. And with that, Angela, do you have any summary of these updates on our business side?
I'm just going to quickly point out that for those of you in District 3, which is Cumberland County, the Board of Governors election is underway. You would have received an email from us this morning through SurveyMonkey. Please vote sometime between today and November 20th. And next week, we'll have Attorney John Kirk from the Ellsworth area joining us to talk about real estate in the during the pandemic. They've been busy.
All right. Thank you. And everyone who hasn't, please get out there and vote tomorrow. Have a great week. See you next week.